Good evening, ladies and gentlemen. On behalf of the Bar Association of Sri Lanka, I welcome all of you, the resource persons and the panelists, for this inaugural webinar organized by the Bar Association on a topic of contemporary relevance. Since its inception in 1974, the Bar Association has gone through to protect the rights of people and rule of law, and today is one of the most important days in the history of the Bar Association. Technology has been discussed, use of technological means have been discussed over a period of time, and the necessity to introduce technological mechanisms for court proceedings and also as a matter of communication between our members has been discussed for a long period of time. In 2019, we organized several continuing legal education programs as part of the CPD program, which we wanted to introduce. And today, for the first time, the Bar Association is introducing the webinar series, which commences with the topic of contemporary relevance in the situation that we are going through in this country. Industrial relations and the labor law after COVID-19. Ladies and gentlemen, at the very outset, I must thank the members of the Bar Association staff, and specific thanks should go out to our energetic secretary, Mr. Rajiv Amarasuriya, whose brainchild this idea has been. I must thank Ms. Amarasuriya for the enthusiasm and the tireless nights that he spent organizing this program, and also specific mention of Mr. Pasindu Silva, who took over the challenge in order to put this event together. Thank you, gentlemen. We welcome you, Mr. Alagaratnam, for taking time away from your schedule and for being with us this evening to encourage the members of the association and the others who are non-members to embark as we embark upon a discussion which is of extreme importance. We also welcome Mr. Udita Igalaheva, President's Council, former member of the Attorney General's Department, and a former lecturer for the Council of Legal Education for taking part at this webinar today. We also welcome Mr. A. Saraveswaran, Attorney at Law, Senior Lecturer of the Faculty of Law, for joining us and sharing his experience and expertise on a very, very important aspect. Mr. Sarath Ranamaka, Commissioner of Labour, former Commissioner of Labour, we really appreciate your decision and your enthusiasm to join this discussion this evening.
Thank you.
And also, I now call upon, we welcome all of you, the panelists, and also Mr. Kanishka Veerasinghe, Attorney at Law, Director General and CEO, Chief Executive Officer of the Employees Federation, for coming out and helping us with this program. I will now, who will also moderate, Ms. Veerasinghe will moderate this event, and while appreciating the efforts by all of you, I now call upon Mr. Kanishka Veerasinghe to take over.
At this point of time is a nagging question that comes into everyone's mind. So I thought we'll start with, because in the relationship of employment, the concept of employer and employee and the contract of employment is the cornerstone of the relationship and what emanates therefrom, the rights, obligations, and all of that. And without this relationship, the world of work, as we know, will not continue, at least in the context of employment. It cannot continue. So to ascertain whether the relationship or what the impact has of this pandemic has had on employment and the relationship, I would like to first pose my first question to Mr. Sarveswaran, who is a prominent academic and a senior lecturer in law at the University of Colombo. And he has been involved in the world of work-related issues for some time. Mr. Sarveswaran, the question that I would like to pose to you is, in your view, has there been a significant impact on the relationship, or will there be significant impact on the employer-employee relationship on account of this pandemic as we stand today? Because things have come to a standstill. many are questioning as to whether the contract of employment itself has been suspended or has it come to an end. These are some of the questions that are being posed. And we know that terms and conditions emanate from the point of view of parties agreeing with the basics of a contract of employment. What is your opinion on that, Mr. Sarvesanan? Has the contract of employment been suspended as a result of employers not being able to offer work and the employees not being able to come to work?
When it comes to Sri Lanka, it is a welfare state, and the state has intervened into contract of employment. Basically, the nature of contract of employment has been changed by many labor statutes. So here the situation is, when it comes to the present situation, whether the contract will get frustrated. So when it comes to frustration, there is an issue. Basically, it is coming under the English law, not under Roman Dutch law. But because of these supervening impossibilities, whether there is a suspension of contract of employment. But here I can't say it will go to the extent of frustration, but there is a term called in abeyance. So that may be temporary suspension when it comes to certain types of contract of employment. But I can't say frustration, but I can say in abeyance or temporary suspension of contract of employment. It may be possible. Because when it comes to labor courts, arbitrator and the labor courts and all, they have to make just an equitable decision, balance the interests of both parties. So normally when it comes to an employer has to provide the work, and also no work, no wages. That is the normal principle. There is a case, Watson case. But if the employees are prepared and they are in preparedness and readiness, then there is an exemption to that rule. So here I can't say it is frustrated, but we can say to some extent it is in abeyance.
Can I now turn to Mr. Alagaratnam, President's Counsel? Mr. Alagaratnam, what are your views on this subject?
I would say that it's a rather complex area, but I would not entirely agree with Mr. Sarvesaran for the simple reason that it would depend on the nature of the industry. What are the functions it carries out, and whether it has drastically affected the functions of that industry. So that if you take, for example, the COVID during that period, true enough, due to circumstances beyond the control of both parties, workers could not report to work. Now both have to take the responsibility for that. The employer and the employee. Employer suffers, employee has to be sympathized with. And what we have a situation, I would say, okay, at that stage, there is a certain inability to perform. So I would say that there is, whether it's interim or otherwise, there is some form of a frustrating circumstance that has come in due to these curfews and inability to perform. Going from post-COVID, what do we do for the future? Again, it will depend on the industry. Some industries, even if, whether they will pick up, like tourism, travel, restaurants, hotel, whether they will pick up, when they will pick up, and whether they will pick up at all, or whether they'll be virtually dead, is something that we have to consider. So it will have to go on a case-by-case basis. Of course, I may add this caution that frustration is not a doctrine to be used to escape from responsibilities. And it is not something that should be lightly invoked. So there has to be cooperation, participation. So of both the employer and employee, to see, not with frustrating event, whether there is a possibility of adjusting and going on in a certain way, which would bring in an entirely new arrangement, because the former contract as it was is gone, right? And so are we saying, therefore, that for the future we have a different contract arrangement? So I would look at it like that, but it will have to be on a case-to-case basis for certain industries. For example, one cannot say that the supermarkets are really suffering as badly. One cannot say that the pharmaceutical industry is suffering as badly due to this. So those are the matters that I would say look into it and see what can be done.
Thank you very much. Mr. Egaleva, President's Counsel. Udita, you started off your career at the Attorney General's Department with a strong flavor of labor law and labor issues. and the concept of, I'm sure the concept of equity has stood very much with you over the years. I think what's coming out nicely is that, aside from the legalist aspect, when it comes to labor law, yes, business concerns have also got to be taken. But on the other hand, you need to look at from the point of view of employees and the point of view of equity as to whether it would be fair to consider certain positions. What are your views on that, Ms. Egalema?
Yeah, Kanishka, can I first make a small comment on the other two participants?
Please do.
And then come to your question on equity.
Yes.
Now, on the contract of employment, I have a slightly different view. The contract of employment, as you know, is governed by Roman Dutch law in this country. And it's, I think it's supported by Sar de Silva and all these writings. And in Roman Dutch law, the concept of frustration is not recognized, but they have supervening impossibility. But supervening impossibility requires one party giving notice to the other. It doesn't automatically come to an end. The contract does not come automatically to an end. That is the difference between the English law frustration aspect and the supervening impossibility of Roman Dutch law. So therefore, I would not agree with Jeff when you say due to these circumstances, the contract of employment has come to an end. It is very much in force unless, depending on the industry, the employer decides to give notice and say that, look here, I'm taking this as supervening impossibility. Say, for instance, as I think Jeff said, there are certain industries like travel industry, hotel industry specifically, no hope of reviving at least for the next 1 year. So therefore, these industries may be dead for quite a long time, but some industries may revive. Some industries have not been impacted or they are not affected. So it depends on the industry, but of course the incident alone will not put an end to the contract existing. So I would say the contract still subsists. Therefore, the employees, in my view, will have all the rights statutorily given. I know that is not, one might say that is not equitable on the side of the employer, but this is where some kind of a state intervention is required, because as it is, all the labor laws are in force, and the contract of employment, in my view, unless the employer takes up the view that it is now giving notice to the employees that there is supervening impossibility, they are intact. So therefore, equity right now is anyway, I believe, with the employee, as it is, as because the Labor Department is entitled to enforce all the laws. And there is very, very little discretion given to the Labor Department in the enforcement of the labor laws.
So I think we are having a lot of interesting views on the subsistence of the contract of employment. Now let me move to Mr. Ranavira, who had a long-standing career at the Labor Department and who had to play the role of a balancer, I would say, balancing the interests of employers and employees. Mr. Ranavira, how would you look at this situation? I mean, I know that you all used to, Labor Department has a tradition of looking at it from a very equitable point of view. And you do are concerned about the employers, but at the same time, you're more, and that's something that even we don't have any grudge against you all. We never do. But you all look after the interests of the employee, because it's always felt that the employees have a less leverage when it comes to bargaining. How would you view this situation, Mr. Ranavira?
Thank you very much, Kanishka.
Yeah.
You know, being in from the Labor Department, we say always we are much bent on the side of the worker. That's true. That's true. You see, because we were called Labor Department, no, because the labor, basically, with the thinking has changed. India has changed, and now they say employment or employer relations also. Anyway, there are about 42 labor enactments still in our statute books. Out of that, there are about 14 labor laws applicable today directly to the employees and employers. Now, out of this, with this context, background to this COVID-19, what we can think of is the Industrial Disputes Act, whether we can have any sort of area that we can take into consideration, or the Termination Act, TEVA, Termination of Employment of Workmen Act. You see, apart from that, I don't see whether EPF Act also, because the EPF Act, there are certain waiver that can be given by the Commission General of Labour on surcharges. You see, under Section 16 of the EPF Act, if the employee is unable to pay the EPF on the due date, the Commissioner has the power to waive. So it has been done previously also on several occasions. So, and the waiver of the surcharge in 2 occasions. One is late payment to the central bank. The other one is non-production of documents correctly or faulty production, where under Section 31A, that 1% or 2% of the contribution where they don't pay, where they rightly produce the documents to the central bank, can be imposed. So those things can be waived off. Other than that, this is very unforeseen and unpredictable situation. So to apply the equity theory, I know I'm very well concerned with that. I believe that it should be so. But even then, I think we have to think on some other areas that how to get over this situation.
That's a very important point that I would like to actually move on to another.
Anishka, before we go there, can I just have a short interruption?
Certainly.
Yeah, most certainly, Udita's point is well taken about the Roman Dutch law. But my concern is, as we normally say, the Roman Dutch law is the basis of our law. So whether we should look at it as something that has evolved into the modern situation. No doubt we have to be sympathetic to both the employer and the employee. Taking from Udita, if you have to give 1 month's notice in an industry that has crashed, okay? So does it mean the wage has to be paid? Of course, Sarvesaran says, no work, no pay, right? So if there's a genuine crash of the industry, the 1 month's notice will be of little effect practically. So I would not entirely agree with Mr. Udita Egleva. I beg to disagree that the Roman Dutch law is our law. It might be the basis and the commencement, but we have moved away. That's my position.
Thank you very much. Now that brings to a very, also Mr. Ranavira's, he almost came out with a bit of frustration and said that, we have some laws, but hardly any of it might be actually useful at this time of at this. Now, we have been advocating as employers and many even from the employee side, the workers side, we have been advocating for labor market reforms for quite some time, particularly on the basis of research that we have also carried out, saying that some of our archaic laws are inhibiting employment creation or creation of new forms of employment. And I don't think it's unfair to say that our laws are archaic, because the most progressive law, they call it, the Gratuity Act was enacted in '83, and before that it was the Termination Act. And the Termination Act, as we have always long argued, has no place today because it was brought at a time when industries were nationalized and the private sector was curtailed. But we are now living in an era where the private sector is considered as the engine of growth, and there are a lot of restrictions. So the question that I would like to pose first to Mr. Sarvesaran, I believe, since he's an academic and would like to get an academic's point of view, are the labor laws today in time? I mean, are they timely, or should they progress, and should we see more labor market reforms being implemented to cater to some of the new employment that is being generated? Mr. Kalinga Indathisa himself talked about the use of technology. We are talking about working from home during this period. And this is not something new, because I can tell you that even in Sri Lanka, we had provision to work from home, and we have been actually drawing up contracts for some time. So in that context, Dr. Sarveswaran, do you think that the labor laws today, and Mr. Ranavir also expressed some views, are timely, and shouldn't we sort of look at progressing further with labor law reforms? Over to you.
Yeah, because when it comes to labor laws, I would say, yeah, you mentioned about the Termination Act. So when it comes to the Termination Act, actually it was enacted during the period we had the closed economy. But now in the current situation, actually when it comes to the open economy, actually we have to see whether the Termination Act protects employment or generates employment. For example, now when it comes to short-term investment and all, right, if the investors know the provisions of the Termination Act, they will not come to Sri Lanka and invest in Sri Lanka. But at the same time, when it comes to the workers' side, right, I would say now when it comes to termination of employment again, right, when it comes to the Termination Act, I find a provision there, basically the layoff situation could arise. So in that situation, the Termination Act could be used. For an example, layoff is temporary discharge of workmen. So now in this situation, the employer can't go for retention. Basically, retention is a permanent one. But a layoff could be a temporary discharge of workmen. But still, under the Termination Act, if the workers come under the Termination Act, then the employer will have to get the consent of the employee or the approval of the commissioner. But when it comes to the commissioner can give the consent subject to the approval, subject to the conditions. Basically maybe wages, maybe half a month salary or whatever the condition. But the provisions are there. But again, when it comes to the labor laws, they need amendments. But I would say in the present context, many countries have gone for various measures. For example, India, right? When it comes to Uttar Pradesh, Madhya Pradesh, even Gujarat, Rajasthan, and all in the state governments have suspended many laws, suspended the provisions. And also not only India, even Hungary, Turkey, and many countries have gone for such measures. Well, so in the present context, we have to think that present context to protect the employers also. Otherwise, we can't generate employment opportunities in Sri Lanka. Basically, the survival of one party depends on the survival of the other.
Thank you. Mr. Adaratnam, how would you look at our current labor laws? I mean, you have been in practice as well as advising corporates over the years. How would you look at our labor laws in the context of some new forms of employment that are coming up, like working from home or remote locations, part-time work, job sharing, which means you need to prorate wages? How do you look at our labor laws in the context of those new forms of employment that are emanating?
I think our present labor law lacks flexibility. There are certain discretions given to the commissioner under, for example, wages, codes, ordinance. If you don't work, you're not entitled to salary, certain discretions under the EPF, ETF. But that is not enough. Now, Mr. Sarveswaran was talking about laws that suspended in India. Even Singapore has done it. But I don't know whether we can do any laws. But if we're doing laws, we have to do it soon. But Parliament is not in session. That's the first thing. And if Parliament does it 4 months or 6 months down the line, retrospective, it will create confusion. So whether there should be a greater burden placed on the Commissioner of Labour to try to see how he can devise some mechanisms to relax some of these. But then he's stultified by the laws. As you say, overtime. Whether overtime can be to a certain extent in this critical period to retain the workforce, whether you say that you can work 3 days, say 12 hours a day or something instead of working 5 days without asking for overtime. Yes. Night work for women. Those are the type of things to retain the workforce. So whether those type of measures could be adopted under the laws as present is a tough call. So those, in that sense, the labor law lacks a certain amount of flexibility. Of course, I go back to the same point that whether the laws do apply in a situation like this. If we come to the question of a frustrating event, the law assumes, all laws assume that there is an employer-employee relationship where work is available and the man can work, right? But here, if we come to a situation where there is no possibility of work, do all this, whether you suspend it officially or not, whether they will be operative is my next question. But I do agree with you and with Sarveswaran that there is a need to relook at our labor laws, because some of them I don't want to use the word archaic, they're very inflexible. They're not broad enough to cover various modern forms of employment, as you referred to, or even things like outsourcing. Because that's the way it's going to go in the future. After this COVID, employment contracts will take a different turn. It'll be more IT, work from home, flexi hours, all those types of things. And then how do you clock in the hours? How do you consider wages? Those issues have to come up. So you need a real relook at all these labor laws.
Thank you very much. And Mr. Egaleva, you are no stranger to looking at things out of the box. And when you were in the Attorney General's department, I know that you were also assigned a particular important industry, the IT-based industry, and you came to a conclusion that there are certain labor laws that should not be applicable in the context of its operations, particularly in relation to night work for women, and that was very progressive. How do you look at our current labor laws, and in your point of view, how do you feel that, if I am to ask you now, for example, we have been talking about the employment contract, but at the same time, we also see a lot of work opportunities being created in the form of the gig economy, where there's no employer-employee relationship between the person delivering and the person producing that goods or service, and there's an intermediary who also gets involved. Now, in the IT industry, they have even been talking about having independent contractor type of arrangements away from the employment contract. How do you see our laws supporting, or our laws evolving to support the gig economy, where there might not be a relationship between the employer-employee? Over to you.
Thank you, Kanishka. Kanishka, I think I also agree with the other two speakers, where we have to amend some of the labor laws drastically, because as Jeff said, there's certain like outsourcing and even independent contractor. The issue of independent contractor, when it comes to courts, still we follow the old case law, where even the newspaper distributor of a area has been held to be an employee. So with that, it's very difficult, as you little while ago said, for intermediaries to operate, because certain entrepreneurs are very reluctant to have this kind of intermediaries, because they claim employment after some time.
That's right.
Right. So therefore, that is one area to be looked into, where especially outsourcing and these independent contractor. Who is an independent contractor? Because we still go by the very old English law authorities and some of our Sri Lankan authorities, where we go by typically, even if there is some control with with one person, that is the employer. And also right now in this COVID situation, even to manage their workplaces in the present situation, where even to reduce some employees on the basis of retrenchment and downsizing the businesses, there is a serious issue with regard to procedure laid down. Because from experience, we know that under the Termination Act, if you make an application to the commissioner, it takes more than 1 year for hearing. And until then, you are bound in law to pay them salaries and all emoluments and consider them as being in employment. So these are the things we have to immediately look into, because not only during COVID situation, but any other situation where there is urgently a business required to be downsized or reorganized for survival, then there is no possibility whatsoever under our existing laws. So there are so many laws in our country, especially during this COVID situation, where we may have to think of either suspending or immediately bringing in some drastic changes. But as Jeff said, Parliament is not in session and we have a serious problem. But at the same time, very little discretion is vested with the commissioner, because the moment the commissioner is inactive, one might go to Court of Appeal for a writ and ask for a mandamus for the commissioner to act in accordance with the law. So therefore, it's a very tricky situation, where that's why I always think that there should be immediate state intervention into this.
Thank
Of
you
course,
very
I
much.
would, if I can interrupt here, I would say
Yes,
on
please.
this type of, sorry for the interruption.
No,
I
that's fine.
agree with everything Udita said, but I also think that in this type of situation, there has to be rationality on both sides, the employer and the employee.
Okay.
They have to negotiate, because if Parliament is not there, commissioners' hands are somewhat tied. Whether there could be some rapport built where the employer and employee by consensual methods resolve some of these things. Like if you look at the big companies, the top management has taken certain cuts. The others have, and they're reviewing it for 6 months to see how they can survive. Then they'll take another estimate at that point of time. So like that, whether you can say, okay, let these people remain, we will bring the other guys on later, or give them 1 month and then bring them back later, and some sort of a rotation based on a genuine cooperation and bona fides. So,
Yes.
because if we wait for the commissioner or legislature, nothing's going to happen. That's my fear. In this particular situation, long term is, of course, you have to amend the laws. That's a different thing.
Yes. I think even in the, I certainly take your points. I mean, all of the, you all have actually elicited a number of important points, which we have also, as the Employees Federation, have been propagating for or supporting for a long time. And we have been advocating for some of these measures, especially the cutting of red tape, where inquiries are concerned, the amendment to Section 17 to take out the inquiry process in particular has been advocated for some time. At the same time, we also believe, even in the context of today's situation, in spite of there not being parliament in place, but using the powers of the minister and the bureaucracy and the government, shouldn't there, Mr. Ranavira, there be some form of empowerment? Because even in our submission to the minister recently, we also called for a similar empowerment of the Commissioner General, in the context of giving him powers, some form of discretionary power when it comes to, cutting short these process-related times, and giving him some form of discretion over and above the law, particularly in the context of meeting some of the requirements of employers as well as safeguarding the interests of employees. Shouldn't that be the case, Mr. Ranavira? Because I will also add by saying that the commissioner, I'm sure in the short term as well, we'll have a lot of disputes to settle, and his the labor department will have to focus a bit more on conciliation and mediation, which is a traditional role that maybe it's being forgotten, rather than the inspectorate. How do you react to that, Mr. Ranavira?
Thank you, Mr. Kanishka. I fully agree with you, and I fully agree with all the experts here that the situation is very, very peculiar, and facing the situation strictly on the last letter of the law is impossible. It's impossible. Cannot go for it at all. As you very correctly said, Kanishka, conciliation, mediation, and trying to bring up parties together to think together and to sort of say collective agreements or any sort of consensus between the parties to come to a fair and amicable settlement. Now, the Commission of Labour is based on fair and amicable settlement, not just order. He cannot make any just orders in any of the labour laws. It's a fair and amicable settlement, trying to bring about a conciliatory process and try to settle the matter amicably. And failing that only, he will have to resort to the arbitration, the arbitration, industrial court, and various other sources that he could use in. As very correctly everybody said, that the commissioner, if you go strictly to the labor law, the commissioner has very little power, and he is helpless, So some sort of suspension or new laws to come in, or whatever it has to be done, if there is some proper solution to this present situation. Because the basic thing in the contract of employment in the labor law, it could be a contract of employment that could be written, that could be oral, that could be implied, that could be expressed. Those four things are there in the ID Act, industry. So if one says come and work orally, that's a contract of employment. So if you say just in writing, small writing, come and work from, that's a contract of employment. Implied, you need not say, but implicate that you are going with the others and working. So that's the implied terms. or the express terms only you find in the under the Shop and Office Employees Act, where you are bound to give a letter of appointment. That is the only law in this country which forces the employer to give conditions of employment incorporating the letter of appointment incorporating the conditions based on the Shop and Office Employees Act. No other law in Sri Lanka gives that there should be a contract. I mean, like a letter of appointment issued. It's only the Shop and Office. So
I'm going to actually going to throw the cat among the pigeons, as it were, and a few issues because there has been a lot of discussion about amending terms and conditions during as a reaction to the effects of or ill effects of the pandemic. One issue was which is being discussed very openly, as well as sometimes taken up at different fora, is that it's about the amendment of terms and conditions, whether employers have the right to deduct wages or ask employees to take a deduction of wages, and how can that be implemented. Now, that's also an amendment to the contract of employment or the amendment of terms. Mr. Sarveswaran, what is your view in terms of such revisions to the contract of employment?
Yeah, actually, Kanishka, when it comes
how should
to
it take place?
Yeah, when it comes to actually, I think Mr. Udita also has mentioned that earlier in one of his papers. Now, here the issue is whether it is deduction or reduction. So, for an example, when it comes to the Wages Board's Ordinance and the Shop and Office Employees Act, so there we have provisions. When it comes to the Wages Board's Ordinance, Section 2 provides for deduction. Again, there is a regulation there. It says what are the authorized deductions, and also with the consent of the workman. Right, that is under the Wages Board's Ordinance. When it comes to the Shop and Office Employees Act also, Section 19 deals with deductions, not reductions. And also again, the issue is when it comes to the deductions with the consent of the workman. But again, the provisions say authorized deductions. At the same time, these two legislation have provisions dealing with contracting out of rights and liabilities. So the situation is whether the parties can go for any agreement against what is in the provisions of the legislation. Because, for example, when it comes to the Wages Board's Ordinance, I believe Section 62 provides for contracting out of rights and duties under the ordinance. And also the same in the Shop and Office Employees Act. I believe Section 70, subsection 3 deals with contracting out of rights and duties under the Act. So therefore, I would say that even though the Commission and the ministers have certain powers, their powers are very much limited.
Mr. Alagratan, do you share the same views with regard to reduction of wages or revision of terms? With deductions, authorized deductions?
With all due respect, I beg to disagree with Mr. Sarveswaran. I take the point from Udita that a reduction is different from a deduction. A deduction is I take away something that you're entitled to. A reduction is I bring about a reducing of your earnings, and that I say is because I just can't pay. I can't keep you working because of circumstances beyond my control. I can't keep you working every day of the month or whatever it is, and I have to. You and I have to take a hit to keep the company going. Of course, this again has to be bona fide. So I think a reduction is something that will not be caught up by either the Wages Board or the Shop and Office Act. That's how I look at it. And as I always said, this situation is an unusual situation, and the foundation or the basis is that our contract is modified or we are forced to renegotiate it because of what has happened. And if you don't consent, then the commissioner can intervene. And in that connection, even the commission, I think, should be a little innovative rather than looking into questions of complaints and inquiries and long drawn out things, whether he can give in appropriate situation, saying he recognizes that these laws in this situation may not be applicable in this manner because of certain reasons, and give general directions, not for everybody, because there are some industries which are doing very well, notwithstanding the COVID. So there are certain criteria that this can be done, and this type of thing can happen because it's not caught up by the law because of the situ. And then if there are any problems, you can deal with that. But if you have to keep going to the commissioner for everything, you're going to take a lot of time, and
That's right.
quite apart from amending the legislation.
Yeah, I think in the private sector, we don't like government intervention that much because aside from determining minimum wages, we say that the market forces and the contractual obligations should be the king and should apply. So if there is a revision, yes, there are two parties. It's up to them to go ahead and make that revision, and then the labor laws can apply. Udita, your views on this, Mr. Igalev, your views on this?
Yes, I think I have always expressed the view that alteration of a contract of employment or a revision of its terms can be done with consent. And many private sector companies have explained to their workforce that this is for survival and we need to all to take a cut. And therefore, they agreed on certain means of cutting down the remuneration and thereby reduction. Ordinarily, it would have looked a constructive termination, but when there is consent, it is an alteration of contract by agreement. And there are certain cases where even recently Supreme Court has held that this consent need not be in one piece of paper,
okay,
or one letter, or it could be series of negotiations, where the consent has come to for the alteration of the contract, where parties agree for the survival of both parties to act in a certain manner. So that is where I believe the Labour Department has to play a major role in getting both parties and arriving at what is equitable and alter the contract of employment without making it a dispute. Because the moment it is a dispute, then the law takes off.
I think that's a very valid point that you are making, Udita. And before coming to a very pertinent point, and maybe I'll come back to you first, Mr. Igalev, on that.
Yes.
Mr. Ranavira, now you heard earlier we heard all parties, and I provoked that question as to whether the Labour Commissioner should be empowered with certain powers to look at certain things, and now it's very clearly coming out that he should exercise those powers in an equitable manner. Also looking at the current situation, I know it's unfair to call upon you to represent the Labour Department now, but since you're one of the most senior officers that the department has produced, can I pose that question to you anyway?
Yes, I fully agree with you, Kanishka. This mutual agreement and consensus and the consent of the worker, that's very important. Consent for any reduction or now authorized deductions. If you try to stick to that, Shop and Office Employees Act just says limit 60% only, not more than that. Authorized deductions. Then wages boards 50%. Now these are things that still in the law. So these things I don't think can be sort of strictly adhered to, but then in this situation. Anyway, what is more, now say for wages boards ordinance, now they are at the minimum wages, but never out of the 43 wages boards where we have different types of employment, they never stick to the minimum wage, much higher than the minimum wage. Though the law stipulates the minimum wage, once we go to the wages board meetings, we find that there is clamor for higher wages, higher salary, and employers federation, employers agree on that on higher rates, and the unions agree on higher rates. Though the minimum wages rule is there, tripartite consensus, but then after discussion, say the 13,500, the national minimum wage. No wages board has stuck to that. They are paying much more than that because they claim, and that everybody knows that that's not enough. So likewise, we have got to have a free and fair discussion, amicable settlement, conciliation, mediation as it is. But in the time to come, as very correctly, all of you all very correctly, eminently told that the commissioner must be empowered. So for that matter, we have to go forward.
Because we don't have much time. I mean, in the sense that I know that it's, I don't want to predict doom, but we know that the situation is so severe that the issue is that the entire economy of the world has come to a standstill. So although we might start up, it doesn't mean that our goods will end up in the markets anytime soon. And even in the case of tourism, it's predicted that that will be one of the hardest hit industries and the last to recover. So I think we need to be very pragmatic in our approach. I think there needs to be consensus about continuity of business as well as ensuring livelihoods. Now, on that note, we have been talking about the statutory laws, and we know that the judge-made law using the doctrine of stare decisis has played a major role, and employment is one area where the judges, in spite of the inflexible laws and things like that, have somewhat understood and use the concept of equity to strike a balance between the interests of employers as well as employees. Udita, Mr. Ekaleva, how do you see our judiciary? And they have, in spite of all the difficulties, even the lower courts going up to their lordships in the superior courts have played a major role over the years. You just mentioned about the concept of consent and how they have recently decided on certain matters. What do you see the role? How do you view the role of the judiciary in the context of all the new developments that are taking place in the world of work, as well as in the short term, the approach that they would have in relation to matters that they may be called upon to decide on employers as well as employees in the context of the pandemic. How do you see this taking place?
Thank you, Kanishka, but I might start from the last comment. The laws can be made by only by superior courts. And by the time the disputes that has arisen now come to superior courts, it will be 5 years down the lane. And many people would have forgotten that there was a period like this. So therefore, although the courts have been looking at certain interpretations, liberal interpretations, I would say in certain areas it has not been happening, especially in the area of casual employee, in the area of outsourcing, in the area of independent contractor. Courts have been following, I think, about 100 years old cases. There had been no new development in these areas. But therefore, I am a bit reluctant to say that the role, or rather the superior courts, will be able to help us in this situation. Because by the time it comes to them, the dispute has taken place wrong time. And therefore, it is too late for them to address the issue. I think before that, we have to see what are the existing means of how we could use the existing law to address the issue. And mainly, I would say the relationship with the trade unions. And if you use the trade unions ordinance and the relationship with the trade unions and agreements that are permitted under the Industrial Dispute Act by collective agreements and so on, through these things, we can do a lot with the intervention of the Labor Department. So right now, what I feel is that there is very little flexibility in labor law, except for this conciliatory and mediatory path where we can enter into certain agreements, collective agreements with the help of the unions, because they will also understand this for the survival of both parties. So that's my comment on that.
Mr. Alagaratnam, your views on how the superior courts could play a role in developing our law, not only as a reaction to the pandemic, but looking at the new developments in the world of work, like job sharing, working from home. How do you think they would be with your?
I'm afraid I have to somewhat agree with Mr. Udita Egaleheva, because what happens is the courts have not been innovative enough in certain areas where they could. And sometimes they're just stuck to the letter of the law. And also because I think labor law is a different ball game. It's a different culture. And when you talk of just and equitable and all these concepts, that sometimes you feel that the appreciation of labor culture or industrial law culture is something that has to pervade even the upper judiciary, and to be sufficiently well versed with the relevant principles. It's not like another criminal law case where a person is found guilty of misconduct or something which has to be proved beyond reasonable doubt. So you, as Mr. Egaleva says, that you cannot at the moment, unless you have certain innovative judges, expect too much from the Supreme Court. What we have to look forward is to see how, as you mentioned, gig economy, independent contractor outsourcing, how we can have some positive statement on it via legislation and via the actions of the commissioner and the trade unions and their negotiations. I agree with Mr. Egaleva on that aspect.
And in this context, I suppose there's a huge onus on the Employers Federation. Also, I thought I'll just chip in and just explain that we also thought that aside from the traditional engagements that we are going to have, we will make a special endeavor to meet with the most representative unions so that, you know, we can actually look into their problems and sort of balance it out. Look at their interests as well, because this is not a time to, I know that they are a bit weak right now because the unions don't have the same leverage that they used to have, but this is not the time for any of us to take advantage of that, but other than to reach out to them and see what their problems are and you know, look into their interests and finding solutions so that, you know, we have a common interest going forward of, you know, on one hand, saving livelihoods as much as possible, and on the other, for business continuity. Mr. Sarveswaran, since you're an academic, and would you like to make any observations and comments on this topic?
Actually, when it comes to the question, when it comes to judicial activism by the superior courts, there are areas in which they can. But here the problem is when it comes to our laws, basically when it comes to labor law of Sri Lanka, very much covered by the statutory provisions. So when it comes to just and equitable jurisdiction, we know the Industrial Disputes Act provides that the industrial arbitrator, industrial court, and the labor tribunals can go for just and equitable decisions. But still, they can't make just and equitable decisions in violation of the statutory provisions. So here, when it comes to Sri Lanka, when it comes to terms and conditions of employment, are mostly covered by the statutes, the statutory provisions. So when it comes to the superior courts also, when it comes to judicial activism, when they go for some sort of interpretation, they have the freedom. Otherwise, they can't, because even the superior courts can't make decisions in violation of the statutory provisions. But the statutory provisions are very rigid in Sri Lanka. So that I would say that affects the judicial activism when it comes to the superior courts in Sri Lanka when it comes to labor law. But there are certain areas, of course, they can go for.
Thank you. Mr. Ranavir, I know that was mainly with regard to the judiciary, but even as a labor officer and commissioner of labor, you all had a lot of interaction with the courts and the judges and the Attorney General's department and so on. Would you like to add something to the conversation that's going on?
You know, in very short terms, I can say the most of the judgments coming down from the superior courts have held with the Commission of Labor. Say for even the Termination Act, the time lapse taken for to give orders, the courts have decided it's not mandatory. It's not mandatory. It's directory. Like that, there are so many ways that we can identify where the higher courts have more or less held with the existing statutory laws and interpretations. Anyway, I think to closing, you know, I should say that there should be a labor policy coming from top. The entire labor law legislation and policy should be framed to face the situation without going in, without telling the commissioner is unable to do and his hands are tied and all that. That's accepted. Everything.
Of course, if I may, sorry, Mr. Ranavir, did I interrupt you?
No, please go ahead, Mr. Alagrata.
Yeah. If I may say something else, we talk of judicial activism. There is one aspect that I think the Bar Association also has been advocating for a long time, because industrial law is a separate ball game. It's a different If you look at other countries, you have industrial appellate tribunals where you have seasoned people who are steeped in industrial culture, who determine matters, and there will be a good jurisprudence developing out of this, because you cannot blame the normal judiciary, because if you take a high court hearing an LT appeal, that poor judge has to look at a murder case, a bribery case, and the whole culture changes. Whereas, as in other countries, if you have a special industrial appellate tribunal or an industrial appeal high court, that might help towards the jurisprudence, because taking off from there, there would be, the Supreme Court might be also able to add to that, because it would be a sort of a guidance and a development of the culture at that grassroots level, apart from what the labor tribunals and the commission is doing. So if you have this appellate body, which decides appeals from the LT and from the orders of the commissioner, whether they are EPF, at a high court level, of people who are expertise and well versed in the industrial law, the chances of developing that jurisprudence upwards to the Supreme Court are better, which is something. And also, a lot of our labor tribunal presidents are quite competent. They are attorneys, unlike before, who can go in the normal stream of the judiciary, which is something, it's a long time coming, and we have been advocating it, but for some reason it's not being done.
Yeah, I think, in fact, that was going to be my next question to you, Mr. Alagaratnam. Udita, what about your views? And in fact, unfortunately, we lost a very erudite judge, late Justice Suresh Chandra, over the pandemic, and he passed away in the Fiji Islands. And he was one person who was an attorney at law, very senior counsel, who was promoted to the judiciary because of his acumen in labor law and industrial law, industrial relations. What are your thoughts, Udita? Because this has been going on even from the, we have the president of the Bar Association, and now we are in a bar forum. And this is something that even the Employers Federation has been advocating for some time. We thought, I think it's high time that we bring it up, because we need to see some changes in respect of, I think you yourself brought some of the issues up. I think this might be a good time to look at those issues. What are your views on that, Udita?
I think I also agree with Jeff, where we have to have some specialized tribunal, because unfortunate that Supreme Court decisions are not consistent. Certain judgments are very progressive, but certain judgments are not. So it depends on the particular judge who is looking at it, and he saw her experience in this area and the knowledge. So we have to develop, because this is not something you can develop in a judge overnight. You have to train certain judges for this, and their career path should be right up to the Supreme Court, should be along with that, because we have very substantial number of labor matters coming up in all these forums: High Court, Court of Appeal, and the Supreme Court. So therefore, it is not in vain if all parties responsible take this opportunity to create this path of career path for the judges to develop the labor law, because that is a very, very important aspect for any economy in any country.
I think I know that the number of members of the lordships in the Supreme Court, Court of Appeal, as well as in the other courts have reached out to even to us for material and things like that on some of the new changes. So that's very progressive. But I do agree that there needs to be much more to be done in that sense. On that note, we have half an hour more. Should I now move to the questions, or would you like to take up any matter of your choice? Now, I have been actually moderating this session, but Mr. Alagaratnam, Mr.
I think I've said what I had to say.
Yes.
If it comes up in the course of the questions, we will discuss it. Of course, adding to Mr. Egalaheva's position on that we must see a consensual approach to this COVID crisis on consent. And as he rightly said, Udita said, it doesn't have to be one document, a signed document. There can be even consensus by conduct. Like I said, let's agree to a pay cut for 6 months. We'll review it and do it, and you pay. And that's consent. So as Sarat said, contract can be oral, consent can be oral or by conduct. So this is a situation to tide over. Both have to work together, the employer and the employee. And it's better that they work it out, because as we discussed, the labor laws are too rigid. The commissioner doesn't have much of a flexibility. Parliament is not there.
That's not the best situation to be in this scenario. But I think, yes, we must not forget the fact that, we also have concepts such as tacit consent. I think these are very important aspects that the judiciary, I'm sure, that's why I asked about the judiciary as to whether they would be in a position to look at things more equitably rather than only the letter of the law. So that these are some of the important aspects that we will anyway need to watch and see in the time to come. Now, the questions are, I suppose, it's the first one is actually, there are a number of questions. There are 28 here on the Q&A, but 10 which has been given to me by Pasindu, collated and given. There's one question to Mr. Ranavir. I think you almost answered it. Is there any provision in the EPF and ETF Acts in the form of relief for employers? I believe the question is whether the commissioner has the discretion, and also whether the ETF board under section 27 has the discretion to allow delays without imposing surcharges. Over to you, Mr. Ranavira.
Yes, of course. We have had that previously also some time back. The commission had the power under section 16 of the EPF Act. He had the power to waive, these unavoidable circumstances. I mean, the employer is bound to, he cannot pay money on the due date. So there can be always a case where the reasonableness of the delay could be understood by the commissioner, and he can waive off the monthly contributions to the central bank as same as the details and other individual accounts of these members also could be without that surcharge. He can waive off. There is no question about that.
We need to have hope. We are not yet gone to the dogs.
Yes, I think that would suffice. No, I think.
Yeah, thank you very much. I think then there's another question. Again, it's an issue of the inability for employees to come during curfew. I suppose this question, it might be related to me. So is it okay if, with your permission, shall I state this question and answer it? Because I think I think we all know what the answer is.
Most certainly.
Yeah, some companies are requesting employees to apply for leave for the curfew period. Now, the issue is, as Mr. Alagaratnam, all of them pointed out, there is a fundamental issue about how the contract of employment operates, and whether the employer himself was actually in a position to offer work. Now, we always advise companies that in curfew situations to be mindful of the difficulties that employees also face, and to be equitable in those decisions. So, if an employee is unable to come due to curfew, well, it's not his fault. So there is an issue about asking him to apply for leave, and that is why we actually to address some other difficulties employers are faced as to whether they should be paying wages and so on. We arrived at recently about 3 days ago, an understanding with the Commissioner General of Labour, so now with the Minister of Labour, and at the apex level involving all tripartite partners, we came to an understanding that might be a solution to that. But these are difficult questions, but you need to answer them and give relief in terms of equity. So the answer to your question is, well, we would not advocate such a policy. There are other ways of looking at things. But of course, if the employer provides everything, curfew pass, if he provides transport to those employees, then if they refuse to come, then the normal policies with regard to attendance will have to be applied. If they don't come to work without any explanation, our advice has been call for explanation and then place them on no pay leave in the first instance, right? But to ask an employee to apply for his own leave, especially when even the employer's establishment is closed due to curfew is not something we think is equitable in these circumstances. Yeah, please do.
Yeah, Kanishka, now I had the opportunity of looking at the agreement you all have reached with the minister on this issue of paying wages for the period staying at home. But how, I'm just wondering, how did you all overcome the situation in terms of Section 35 of the Shop and Office Employees Act? Because Section 35 of the Shop and Office Employees Act says that if an employee is not provided with work without his fault, then the employee is liable to pay his remuneration.
Yeah. Now, technically, if you look at that, technically, Udita, yes, that's a case of a lockout. This is the opposite of a strike. So this is where we need to strike a balance, and that's why we had a understanding at the highest levels, because in 2012, I think Mr. Ranavira was in the Labour Department at the time, and the Commissioner General was Mr. Upali Vijayveera. Or had you retired by then? I'm not sure whether Upali was there. Yeah, Mr. Upali Vijayveera was the Commissioner General, and at the time, Mudita, we came to an understanding with regard to a concept called the 5-day week. That is, like in the case of the poor conservation law, we applied those principles. Even that time, there was a bit of a financial crisis, and some of the companies said they just don't have the time, the money to pay overtime and things like that. And as a quid pro quo, we also allowed 2 days of holidays for the wages board categories, which we normally get only 1 holiday. Yeah. But the understanding was that we apportion the 5 days of 5 hours of work that is normally worked on the short working day, which is usually a Saturday in terms of the wages board's ordinance. Sorry, sorry, I have a Labrador here with me.
No problem. Man's best friend.
Yes. And we apportioned it, the 5 hours over the weekdays. That is working 9 hours of actual work without overtime. That was another agreement that was reached at the highest level and applied. So we took the same example, and we thought that we will apply it now in the absence of Parliament and so on, because of the urgency of the situation. And also Section 35 also contemplates that the employer is not in a position to offer work. But here we are in a position to offer work, but we can't do so because of the restrictions placed by government. Because government is the one that is saying, look, if you have a complement of 100 workers, you can only bring 50. That's not our fault. So we needed to reconcile that situation. Also understanding the government's objective of ensuring health and safety of the workers, right, and health of the country. So I think we wanted to strike a balance in that situation. So we discussed this matter at length, acknowledging that this health situation is going to continue for some time. It's not going to end anytime soon. Acknowledging the fact that the employees needed to be paid wages of some sort so that they can live, but at the same time looking after the interests of employers who say, look, otherwise I may not have the money to pay or retain employees. So we wanted to strike a balance, and this agreement came as a result of the absence of some of the laws that could have facilitated this. And unlike in India, India has suspended 52 labor regulations and laws, both state and federal. So in the absence of that, we came to an understanding, again based on tripartite values, which the ILO conventions themselves actually propose. We looked at the latest convention. I'll speak on it a bit. Just hold on, because it's important that I bring this forward, which was also advocated by the Director General of the ILO, which talks about the requirement. There are some ILO standards, interestingly, which provide for some guidance, as to how we should approach these matters. One such was concluded quite recently, that is on peace and reconciliation. And one of the points that was highlighted even by the Commissioner General is stabilizing livelihoods, income through intermediate social protection and employment measures, promoting economic recovery for the employment and decent work opportunities. So if you are to have economic recovery, you need to have the companies in place, because without the companies there won't be laws and there won't be economic recovery. But on the other hand, you also needed to protect the livelihoods of employees. This is the balance that we struck, Udita. Even in the 5-day week context, we actually went according to one of the oldest ILO conventions, the Working Time Convention number 2 of ILO, which allows employers and employees in consultation with each other and also with the government as the tripartite partner to come to some understanding with regard to enhancing the workday from 8 hours to 9 hours in the case of exigencies. So that we actually took those values into consideration, and that there is a precedent, which is the 5-day working week, which was entered into in 2012. And since this was arrived at the highest levels under the aegis of the government, under the Ministry of Labour, we had unions being represented on the task force, employers being represented on the task force. I think it's actually a win for social dialogue and what we believe in tripartism, and because this also enables or gives employers the confidence to keep on employees on board for longer than we would have be envisaged, because now it gives the confidence of employers to rather than thinking of strategies such as maybe temporary non-employment and things like that, to actually offer these employees an opportunity to work on rotation because of the limitations that are imposed on them by some other force. That's currently it's the government. So we thought that it was well worth pursuing, and I'm happy that the understanding was reached. Thank you.
Kanishka, can I interrupt there? There was just one. The question was somebody compelling the employee to apply for leave during the period they did not work. Now, that doesn't sound good anyway when you compel a person. But it's another alternative where it's consensual, where I say, because rather than say, I'm not going to employ you for 1 month, are you agreeable that you will not avail of the leave? And then this can be set off during this period for the rest of the year because I'm paying you for all those leave, right? And you're continuing to work. So if it's a consensual approach by which employees accept, okay, fine, we were not able to work, not your fault, not our fault, but we'll set it off against our leave, you pay us for that and continue to employ us. So that is, I think, a fairly good compromise.
Yes.
So
no,
the way
that's perfectly taken. But here the question was about compelling a person.
I know.
So that's it's in the context that but I take your point, Mr. Alagaratnam. It's absolutely fair when everything comes through consensus, and this is where even now, if you would have seen, Udita, if you're referring to our circular, we also emphasize that wherever that these things have to be implemented in discussion, after educating employees, in discussion with employees, and wherever collective agreements are in place, we have to respect those provisions, and you have to discuss those matters with the unions. And also there are companies which have in addition, other than unions, they also have worker councils which have worked well for so many years, especially in the manufacturing sector. So we encourage social dialogue, and because the solution was found through social dialogue, and we are also encouraging and reminding employers the importance of keeping that going, because whatever that is done through consensus will have better results than something being forced on employees. Thank you.
I think, thank you, Kanishka. I think that is based on the fact that it is by agreement you have altered the condition. So there is, I think, perfectly fine and legal.
Yeah, thank you very much. Because we, unfortunately, as all of you know, that we don't have a parliament now. That's a huge problem for everybody. But at the same time, I must, I'm not saying this as making a political statement, but we are extremely thankful to the government for ensuring the health of all of us by imposing, strict conditions. I know life is tough for us, but the fact that we have had less number of infections as well as less number of deaths and the round-the-clock work of the public servants, especially the tri-services and the police, has been marvelous. So I think we are indebted to the government. But on that point, I think, gentlemen, you will also agree that there needs to be a bit more cohesion with regard to the government apparatus itself. And I would like to ask your comments on this. It's not a legal question, but it's more about cohesion. But cohesion can bring better results. Now, for example, recently we had a situation where because of one infection in one company, one particular manufacturing company, the entire zone was closed. So we need to avoid such situations as well, because we need cohesion amongst the the bureaucrats. Any thoughts on those matters? I mean, because we are not only talking about the law, but also building confidence of all stakeholders.
If I may interrupt there, Kanishka, what I would think is, yes, there has to be more cohesion, especially from the medical point of view, because there are the medical people who are upfront, who should know best as to how this isolation and quarantine is done. So they are the experts on that field. So no doubt the Triforces are doing a commendable job, but we cannot fail to emphasize the need and the necessity to follow what the medical advice is and go into that, and make sure while we take the precautions that we don't overkill. And coming to the government, as you say, even Parliament is not sitting, but there are other aspects. Here too, I don't want to make a political statement, but if you look at things like the emergency, if the emergency was invoked, everything except the Constitution can be suspended by the President, or whatever it is, certain laws can be held in abeyance. Now that is where you could have gone a long way in sorting out some of the labor problems if we had this type of situation. So that is one aspect.
One of the things that has been posed as a question, I would actually ask this from Udita, pose this question to Udita. In this situation, can the employer deploy its employees in different job roles?
Yeah, I saw that question. I think what they're meaning is that different legal entities.
And also different legal entities, yes.
Yes, but I don't think there is major issue in assigning a different task, if I may say, rather than what they have been continuously performing, if they are capable of performing the second task. But technically speaking, this practice has been adopted by many companies, not knowing the legal consequences, where one company employs and then transfers to a completely different legal entity, which you have to view as a new contract of employment. So subject to that again, if it is with the knowledge of the employee and if there is consent, and if statutory payments are not disturbed, well, I think there is no serious issue in a time of this nature, where we can transfer them wherever we can employ them and get some productive work and also help them to survive in this situation.
If I can interrupt there, it's like akin to a secondment. It's not the permanent employer remains the employer. It's a secondment. Of course, when you're assigning him another job, it should be somewhat commensurate with his status and his ability. Like you wouldn't want your IT manager doing the job of a peon. Okay, so it has to be commensurate, and it has to be clear with the consent, as Udita says, of the employee, and a nature of secondment where the permanent employer remains responsible for it.
Thank you. On that note, in fact, we have proposed in our submissions to the minister, it may seem out of the box and out of the ordinary, about loaning employees even to other entities, so as to ensure that they are on the payroll of a particular employer rather than being retrenched. Loaning employees to other entities. I know that this is a bit away from the normal that we know about secondments and deployments and so on. But we thought that we need to bring this out because there's bound to be people who are going to be redundant in some form or another in the even in the long term, because employers may not be able to deploy as many workers as they want. And one of the things that they might do to overcome the restrictions in bringing the entire complement is to bring in automation and machinery. in place of labor. So, so one of the things that we may have to look at is how do we, I know that the government in the short term no government will want to see unemployment, but there's bound to be changes that we need to address in a way that is also realistic, and also in a manner that there's no socio-economic disaster or catastrophe. In fact, we also have gone to the extent of suggesting, Mr. Ranavir, I think you're familiar with the concept of the jobs net, where we said there should be job placement centers and things like that, and to work in hand with the employers as well as the business community, so as to actually at that time this type of emergency was also, I understand, considered. You see, what are your views on that?
Yeah, very correct, Kanishka. Rather than redundancy and retrenchment and losing jobs, if a person can be employed elsewhere, a skilled person using his skills to another job role, I think that's perfectly all right, because he will not lose his job, he has the earnings, and I will not be retrenchment. I think he should be happy and the worker should be happy. I think that's a very good solution. I fully agree, endorse what you say. That's perfectly all right, I think.
And taking from Sarath, I think because the unfolding scenario means that some of the industries, certain types of industries might die, whether travel, tourism, those type of things, and even large hotels, because now you have B&Bs and things like that. So what do we do with all these workers who suddenly find, because of this, particularly because of this pandemic, that they are going to be unemployable? That is why one should be able to also develop multi-skills, fit into other organizations. You may not get exactly the job you had before, but adaptability is critical. And what I think also the way forward is, to a certain extent, a lot of people have to go into aspects of self-employment.
Yes.
Apart from growing your own food at home, that's a different thing. But self-employment, whether those are the things of the future, and because of this gig economy and things like that. So I think we have to be innovative. The workforce has to be innovative. We have to try to find them places, not in the exact places, because certain industries may not exist after this. And that's the way forward, the job net.
I had a look at the questions, gentlemen, and most of it has been answered by you during the course of your interventions. So I don't think it'll be apt to repeat, but Mr. Sarvesaran, on the same issue, now since we also need to look at the employee's point of view and social protection, do you think that, I know that there's a lot of room for improvement. What are the practical types of solutions? I know that you have been involved in some of the ILO research into this area. What are the practical approaches of social protection that you can think of?
Yeah, Kanishka, when it comes to mainly within the framework of our labor legislation, we have to go for innovations, creativity. Because for an example, as you mentioned earlier, when it comes to these flexible arrangements, but when it comes to the flexible arrangements, there are certain barriers, but still we can find a room. Actually, when it comes to homework, or when it comes to part-time work, actually part-time work is another one that is suggested by the ILO, and also now because of the current situation, they are going for it. But it is not prohibited by any of our labor legislation. Because another approach would be, why should we consider the working hours? We have to go by the output. We have to measure the output by the workman without going for working hours. And also now we have to have some sort of flexibility to introduce some maybe shift-based work. Maybe even they can employ the people for 24 hours, 24 hours, but based on shift basis and all. But one other point, actually, when it comes to, as all said, now we don't have parliament now. But anyway, now in many countries, they have suspended the laws for 3-year period. So I would say when it comes to certain laws, certain countries have suspended for 3-year period. So now when it comes to that is anyway that takes long time, but within the existing provisions we have to go for innovations. That is what one, then another one you all mentioned about the transferring a person from one entity to another entity, because when it comes to normal situation that you can't do that, because when it comes to the Termination Act, actually there are cases what happened was instead of closure, the employer transferred the employee to another legal entity without his or her consent. So there it was considered as violation of the provisions of the Termination Act. But with the consent of the employee could be transferred, but the issue will be whether when the person is transferred to another place, whether there will be a new contract. That will be an issue. But anyway, within the existing provisions, we have to go for creativity and innovation to deal with the current situation.
It may be continuity,
That's right. Of course, this is a basic question. I can pose it to Mr. Alagaratnam. I'm sure this is his bread and butter. Can an employer who has offered a permanent contract to an employee terminate his or her services by giving 1 month's notice? They're referring to the notice clause and whether the notice clause can be effected in relation to permanent employment. Of course, we'll have to see whether they are covered by the Termination Act or not.
That's the point. Because if you're not talking about the COVID or a situation similar to frustration, and in normal times where you have a permanent contract, whether the Termination Act, technically, whether we have moved beyond the stage to say there is equal bargaining power now, you sign the contract, 1 month's notice, he can give it to you. But we know that a labor tribunal has a just and equitable power. The Termination Act also has this question of the consent of the workman. You have to either get the consent of the workman or the consent of the commissioner if you want to terminate a person for non-disciplinary basis. So can you say that when he initially signed the contract 5 years before when he joined you, or 1 year before, or more than 1 year, he said he signed and accepted 1 month's notice was sufficient. The commissioner tends to frown on that clause, I know. And the judiciary generally doesn't, because they say the consent should be at the time of termination, not something in anticipation when you originally took up the employment. So there's a lot of dispute on that, but I would think the better view is that it should be at the time of employment because it should be consensual. Just because a guy signed the contract and took it, you can't later foist it on him after 5 years and say 1 month's notice, here, go find your way. Okay.
I suppose on the flip side, it also affects fixed term contracts, because in a fixed term contract, both parties have agreed on the date of cessation well ahead. These are some of the issues that are coming up even now.
If it's a genuine fixed term contract, of course, then that's fine. But if it's a fast, then there is a problem.
Anishka, can I comment?
Yes. Yeah,
can
please.
I quickly on one thing, because we are running out of time.
Yes.
One issue which we did not discuss is situation of a probationer. Because
I was about to come to that to you. Can I ask that question? Now, a lot of employers and also from the side of the employees, there's a dilemma when it comes to probation, the period of probation, because as you know, I was about to ask that question. So you and I are on the same track. Maybe we are from the same background now. Yes. Right. From the Aegis department days. So because this is a dilemma for both parties, so the employer as well as the probationer involved, because you take a probationer and you're supposed to ascertain whether he fits into the company or not. And this is a situation where this COVID has come and sort of created a suspension of all that, because we cannot assess the probation. I suppose the correct. I will allow you to answer those questions. What do you think of this situation? How would you approach?
Really, several persons have referred this in practical point of view, where probationers have been terminated after this COVID situation, basically with a view to reduce the workforce by the employer. So in my view, although a probationer can be terminated without assigning reasons, but that is only when his work is not up to the required standard. So therefore, this is not a situation where a probationer can be summarily dismissed because there is no work due to the COVID situation. So probationer has to be treated as any other employee in even under this situation, because it's nothing to do with his performance.
I agree with Udita on that, because Udita, probation is to prove yourself. So
That's
you
right.
can't say you are proving yourself. If you're not proved yourself, you go. But you can't say COVID has come, you're not given the chance to prove yourself, go home. Okay. So it doesn't work. It's not fair by the probation.
But there could be a situation where what will happen is, if the probationer has completed 180 days, the period of 180 days of work, in that situation, even though the person is a probationer, if his employment is terminated for a reason not connected with his employment or inefficiency or whatever, then it may be covered by the Termination Act. Because when it comes to a probationer, actually there's a judgment given by the Supreme Court Brown and Company case. There it doesn't apply to the probationer. The Termination Act doesn't apply to the probationers when it comes to the termination for the reason of his inefficiency or incompetency or whatever. But if the termination is merely because of redundancy, then if the probationer has completed a period of 180 days, then he may be covered by the Termination Act.
I agree with you, Sarveswar.
Yeah, I think I will just add something. I think maybe you all may have omitted the actual provisions. The provisions say you have to work for 12 months, a minimum of 12 months, and within the 12 months, you have to put in 180 days, inclusive of. So I think, so if the I take your point. So within those parameters, if the probationer exceeds 12 months, I think, and if he has put in 180 days, he will definitely be covered by the Termination Act. And unless he give reasons, it will be very unfair to terminate. But I know that, yeah.
I have a different opinion. If the probationer has completed 180 days, then no need to look at whether the person has worked for 12 months. Because within the 12 months period,
no, sir. The law says that you have to work for 12 months, and within that 12 months, you have to put in 180 days.
It is in the other way. Suppose if the person has worked for 8 months, within the 8 months, he has worked for the period of more than 180 days. And in that situation, why he should be excluded?
Yeah, Kanishka, this issue is now before the Court of Appeal in one of my cases, where the Labour Department says even less than 12 months, if he has completed 180 days, he is covered. But my argument is the other way, but still pending in the Court of Appeal.
Thank you.
Yeah, that's the point, because it's if it's to do with entirely a probationer during probationary period, terminated on the rights of the probationer, failure to prove himself, whether the TEVA will operate is a question.
Is a question. Yeah. I think we have run out of time, gentlemen. So I would like to thank the eminent panel of resource persons, Mr. Jeffrey Alagaratnam, President's Counsel, Mr. Udita Egareheva, President's Counsel, Mr. Sarath Ranavira, former Commissioner of Labour, and Mr. Sarveswaran, Senior Lecturer of the University of Colombo, for joining us and very candidly airing your views on some of the major issues. And I'm sure these issues will crop up in the future, and it'll be easier for all of us to probably understand each other's positions and situations as a result of the views that you have expressed. So on behalf of the Bar Association, I would like to conclude this session, the special webinar on the impact of COVID on employment and businesses and the legal aspects impacting on this issue. So once again, I would like to thank the Bar Association for organizing this webinar, and for the eminent panel of experts for having joined us today. Thank you very much.